researchers traced my genealogy.
Economic incentive to lying about the ethnic origins of slaves long before the colonies became the United States genuinely brought Africans to the Americas. And the mainstream sources admit that very few of them came to North America. The only defense argument available is to claim that these are Africans.
Wake up, wake up, wake up, wake up, wake up, wake up out of your sleep, sleep.
No one talks about slave courts when we discuss antebellum history in America, and that's a massive oversight. Several colonies and subsequently states had slave courts which heard cases predicated on lawsuits filed against owners by slaves. We now refer to those cases as freedom suits. The arguments were usually the same on both ends. The plaintiff argued that they should be free because they're indigenous, and the defendant argued that they should remain enslaved because they're African. As far back as the mid-1700s, you had these positions being argued in the trials of courtrooms in a variety of jurisdictions. We're going to look at how and why this was happening, but first, take a second to consider the ramifications of this. Why would it take litigation and due process to prove that an African wasn't American Indian? Think about it. Can't you just tell by looking at him that he's not indigenous to this land? Short answer, no. These cases were necessary because, whether you want to believe it or not, American Indians looked so phenotypically similar to the African slaves that Europeans genuinely couldn't tell the difference between them. Conversely, for those of you who insist that no slaves were brought here from Africa, the truth is that slave ships genuinely brought African slaves to North America in small numbers. Otherwise, no one would have needed to argue about this. However, the largest mainstream statistic provided for how many African slaves were brought to the North American mainland is only 388,747 people between 1619 and 1860. Yet the 1860 census records this population as having already swelled to 4.4 million people. There is no feasible human birth rate that can bridge that gap, which is how we know the bulk of that figure must have already been here. Due process of law in the context of the law that the child follows the mother apropos of slave status or freedom. Partus Sequitur Ventrum de Jure. We're reading from the Library of Virginia Education, which is a mainstream.gov site. They've archived a photocopy of an authentic handwritten slave genealogy entered into evidence in a Virginia slave court as of 1804. And they provide a discursive description of it with historical background included for context. We're going to read the historical background first to validate what slave court even is, but also to get an understanding of why this genealogy was submitted as an exhibit in court. It starts by explaining the most relevant act of assembly. An act of assembly is a local law of the Virginia colonies legislature. Quote, 17th century acts of assembly allowed enslavement for limited time periods of Indians captured in battle and lifetime slavery for Indians purchased from other colonies. In 1691, the assembly outlawed the enslavement of Indians. Nevertheless, people of Indian descent were still held as slaves, and laws concerning the enslavement of Native Americans changed several times, leading to confusion and lawsuits to determine whether people descended from certain Indians were legally free or enslaved. In 1662, the General Assembly had passed a law stating, whereas some doubts have arisen whether children got by any Englishman upon a Negro woman should be slave or free, all children born in this country shall be held bond or free only according to the condition of the mother. In Virginia, then, the status of the mother was passed to her child. Therefore, enslaved women gave birth to enslaved children, regardless of the status of the father of the child, or the children, I should say. But the same was true of free women. Their children were automatically free. One path to freedom for a slave held in Virginia was to prove maternal descent from an illegally enslaved Indian woman. Many people gained their freedom by showing that their mother or grandmother was an Indian and therefore was or should have been legally free. End quote. Okay, so basically in 1691, colonial law made it illegal to own American Indians as slaves, but all the prominent local colonial families already owned slaves. Nearly all those slaves were American Indians, with only the rarest exceptions. How do we know? Because it's well documented. Voice of America is America's biggest international news broadcaster, and when I did my presentation on the Chichimeco Empire, also known as the Westo Nation or the Savannah River people, I showed you what I'm showing you now. This is Voice of America saying, quote, "Slavery in America is usually associated with Africa and the American South, but Ohio State University historian Margaret Ellen Newell told VOA, Voices of America, that up until 1700, Native Americans comprised the majority of slaves in America." End quote. In fact, the Slave Voyages database reports only 11,000 foreign slaves had disembarked on North American soil by the year 1700. We have to take all the moving parts into account here. So most slaves were indigenous when Virginia outlawed the enslavement of Indians, and by that time they had already mandated 3 decades earlier that the status of the child would be determined by the status of the mother or grandmother, even if the grandmother's several generations back. But the excerpt we read from the Library of Virginia Education just now told us that one way for a slave to become free was to prove matrilineal descent from an Indian in a court of law. It also confirms that many people, quote unquote, gained freedom that way. So when you find freedmen prior to emancipation in certain states like Virginia, Maryland, or the Carolinas, for example, there's a very good chance that this is how they gained that status. We're going to read the rest of this too, but think about this for a second. If you're a slave in 1695, you're most likely an Indian according to mainstream stats, yet you now need to prove you're an Indian in order to gain your freedom. Why do we need witness testimony, opposing litigators, and a judge to figure out whether or not you're an Indian? There's 2 main reasons. The primary reason is because slave owners don't want to lose slaves because that's a loss of property. Subtracting assets directly impinges upon net worth and productivity. In many cases, it was you and several siblings all petitioning for freedom together. So this owner is about to lose a massive swath of his workforce. It's only logical that he's going to argue that you're not actually an Indian, and that's why we even have a case here. Everyone knows slaves tend to be Indians, but if the owner claims you're not an Indian, then that means he's not breaking the law to keep you enslaved. Don't forget, he's the defendant here. You're suing for freedom, which makes you the plaintiff. He has to defend himself against the claim that he's illegally working you as a slave. The court will give him the benefit of the doubt when he says you're not Indian, but then the question remains, what are you? What do you think he called you in 1695 if he's saying you're not an Indian? What else could you be? African. You have to be an African. What I'm showing you is that there was a systemic economic incentive to lying about the ethnic origins of slaves long before the colonies became the United States, long before there was a national census. There were very good reasons for slave masters to claim that American Indian slaves were actually African. This is also the beginning of the confusion about the size of the colored population in America for modern demographic historians looking backward, because it creates a bunch of phantom Africans that researchers are struggling to substantiate today. The secondary reason why we needed a whole court proceeding to figure out if a slave was Indian or not, even as early as the 1690s, was because Africans genuinely did get brought to America. But the American Indians and Africans looked indistinguishable from a European perspective. I know many of you prefer to deny that any Africans were brought to the Americas at all. This channel focuses on mainstream evidence to demonstrate that no one's deliberately lying to you. The white man is as confused as the black man. He's not hiding Negro identity. He genuinely doesn't remember. Slave ships genuinely brought Africans to the Americas, and the mainstream sources admit that very few of them came to North America. They came, though, so it was necessary to make sure the slave in question wasn't African. What's interesting, though, is that the Amerindian phenotype had to match that of the Igbo, that of the Yoruba, that of the POWs in the Congo, in order to explain why we can't just eyeball an Indian and know that he's not African. I mean, if American Indians then looked like Native Americans today, no one could claim they were African, right? So what we're seeing is that slaves were African until proven Indian. And that dilemma has persisted all the way to the present day. As we speak, you are African American until proven American Indian. Is that not the case today? This created a culture of equating slave with African, regardless of the origin of the slave in question. Let's get back to reading the historical background for that handwritten genealogical document. Quote, in the May 1772 case of Robin versus Hardaway, the General Court ruled that for most of the 17th century it had been illegal to enslave Indians who had been brought into Virginia. That case, on which Thomas Jefferson, a young attorney, took notes, resulted in freedom for 12 Dinwiddie County descendants of Indian women who had been sold into slavery in Virginia between 1682 and 1748. Some cases, like the one of Charles Evans and others versus Lewis B. Allen, used evidence proving descent through many generations back to the original Indian ancestor. This genealogical chart and petition listing the descendants of Jane Gibson, who was described as an Indian woman, quote unquote, were submitted in evidence during a Lynchburg court proceeding that began in 1804 to secure the freedom of her numerous descendants who had also been held in slavery for their entire lives. That case was never resolved. The court-appointed lawyer for Gibson's descendants suffered a nervous breakdown and failed to follow through on the case, leaving the unrepresented plaintiffs enslaved. End quote. So first off, what we just read let us know about a case in which a slave owner was proven to be operating illegally by keeping 12 slaves who were actually supposed to be free because they were secretly Indians. They had to prove that they were Indians based on descent from a specific Indian woman who was sold into slavery in either the late 1600s or early 1700s. They succeeded and won their freedom. Next, we finally get to the case from which this document comes. Charles Evans et al. Versus Lewis B. Allen. This case was heard in 1804, and the enslaved plaintiffs were assigned an attorney by the district. The plaintiffs had been enslaved their entire lives, just like the 12 slaves from the other case. Their case was suspended indefinitely, however, because their attorney conveniently and unexpectedly refused to continue the case, due to having, apparently, a nervous breakdown for some reason. So they remained slaves. It's not impossible that foul play could have been involved here, but we have no way of confirming any of that. What we know is that the owner's argument was that the plaintiffs weren't indigenous, which meant he was either implicitly or explicitly calling them Africans. By 1804, there were a lot more African slaves in the region, but this genealogical chart goes 6 generations back. If these generations average out to 20 years apiece, that takes us back to 1684 when the Africans were rare. Their claim that Jane Gibson was indigenous was statistically likely to be a solid claim, even if she bore children closer to the year 1700. The plaintiff was multiple people, which is why the excerpt we read occasionally pluralizes the word plaintiff. This slave owner was about to lose multiple assets in an era when wealth was measured in literal human resources. The only defense argument available is to claim that these are Africans.
Hey y'all! First of all, like and subscribe to the channel, but also, Unahia is recruiting, and if you don't know what Unahia is, we're a grassroots activist group lobbying Congress to amend a bill to require education and research to acknowledge the Negro origins of Aboriginal groups of North America. If any of you have it to give, please support the campaign using the QR code on your screen. Join the campaign with a donation, and if you have the time, you can even join our staff to help guide the organization, not just for this campaign, but also future endeavors. Don't speak about it, be about it. Let's go.
Another key point to consider is that it was often hard for enslaved Indians to prove that they were Indians. So Pan-Africanists might argue that this is because they were actually African, either entirely or in large part. That's just jumping to the comfortable conclusion. In reality, slaves were frequently separated from their families either as children or as young adults. According to the Equal Justice Initiative, quote, roughly half of all enslaved people were separated from their spouses and parents. About 1 in 4 of those sold were children. End quote. We usually assume these were Africans, but the slave trade numbers indicate that very few of them were, as we already covered. This means slaves were taken as children and sold to end up separate from their parents, which cuts them off from the connections that would substantiate their claims if they sued in court. How do you prove your ancestry without your parents or grandparents? And don't think everything we're discussing was just a Virginia thing. This was actually the case throughout British North America. We'll get an example from South Carolina, courtesy of the Charleston County Public Library. Quote, tensions between the colonists and the native population increased as the years passed, and in 1707 our government ratified a law to regulate trade with the Indians and to make such trade safer for all concerned. For our present purposes, there was one very important clause in that law to regulate the Indian trade. In 1707, our legislature explicitly recognized the perpetual freedom of all people of Native American or Indian descent who were in amity with the government of South Carolina. That is to say, the members of tribes who were friendly with or lived in harmony with the European settlers were considered naturally free. For some, skipping down here, for some, their families had been free for generations, and perhaps they weren't even sure of the exact circumstances that led to an ancestor's manumission. Pause right there. It's 1707 in South Carolina. If your ancestor was freed from slavery multiple generations ago for unknown reasons, then your ancestor was almost guaranteed to be an Indian. Why? Because Africans they're only just now being trafficked here to any large degree. A freedman in the 1600s was an Indian freedman, and that term didn't have anything to do with African ancestry yet. Continuing, quote, Under increasing legal pressure to provide documentation, however, some turned to genealogy for their defense. Knowledge of the 1707 Indian trade law apparently circulated through the free-colored population, and scores, perhaps hundreds, of FPCs, that's free persons of color, informed white authorities that they had a bona fide claim to be free because they were descended from Indian women who once lived in amity with the state of South Carolina. Since our law dictated that the condition of the child followed the condition of the mother, the claim of having a female Indian ancestor, no matter how far back in the past, represented a valid claim to freedom. For hundreds, perhaps thousands of people living in 19th century South Carolina, having a woman of Native American ancestry in your family tree was never more important or desirable. End quote. No African had been here long enough by the early 1700s to become a freedman. Voice of America already confirmed that very few Africans had arrived by then, and mind you, they'd be scattered from Louisiana to Florida, then up to the Chesapeake regions. They wouldn't have been concentrated in any single colony. This is the exact same situation in South Carolina that we saw in Virginia. And I'm showing you this to demonstrate that it doesn't actually matter what colony or state you research. This is just how it was. Indian slaves needed to prove they were Indian to be free, and thousands in South Carolina alone claimed to be indigenous. Moreover, slave trade statistics suggest most of them were probably telling the truth. Here's another example in Maryland. I'm pulling this excerpt from the Native Heritage Project. Quote, "Things were different in Maryland. However, there was apparently some doubt based on this Anne Arundel County, Maryland record from the court proceedings 11 January 1708, 1709, page 552. Captain William Harbert presents an Indian youth, the son of an Indian captive woman taken at the Susquehannock fort, and desires to have the court's opinion whether he be a servant during life, as his mother was, or not. It is the opinion of ye court that he is a slave during life." End quote. So in some cases, having recognized Indian descent still wasn't enough to free slaves. This was usually based on whether or not the tribe from which they came was friendly or hostile from the perspective of the colony in question. Maryland and Virginia warred the Susquehannock around this time. The bigger takeaway here, though, is that Captain William Harbert wasn't sure if he could keep the slave indefinitely or not. The only reason for uncertainty was that the boy descended directly from a known Indian woman. We've seen 3 examples in 3 different colonies of slaves having the opportunity to become free based on descent from an indigenous woman. This satisfies the Ichiti principle of discernment. 1 is an incident, 2 is a coincidence, 3 is a pattern. By proving a pattern of these circumstances, regardless of which colony we observe, we demonstrate that colonial Americas had a widespread economic incentive to classify slaves as Africans. They had no database to track how many Africans were actually being brought to mainland North America, so they have no concern about inflating numbers well beyond what's later verifiable. This is how it started. Indians were being labeled Africans before there were even that many African slaves in North America in the first place. Moreover, the African and the Indian looked alike because they were indistinguishable from one another, necessitating court proceedings to investigate the ancestry of slaves petitioning for freedom based on Aboriginal descent. That's because the Negro race was an intercontinental race of people scattered all over the world long before the colonizer reached America. Very few African ethnic groups are actually Negroes, but they happen to be the ones trafficked in the transatlantic slave trade. I've discussed this in previous presentations, but I'll be exploring it more in the future. Believe it or not, the slave trade ended up reuniting an ancient black ethnic group known as Negroes. The Negro race is a black race separate from that of Africa. The origin of the Negro is actually neither African nor American. The Negro is a copper-colored race that once dominated ancient and even prehistoric Asia. We'll cross that bridge when we come to it, but suffice it to say that the American Indians of Turtle Island were being called Africans in slave court when they filed freedom suits. These are the freedom suits that no one talks about because the mainstream attention for freedom suits oddly focuses only on cases in which slaves achieved freedom by means other than proving Amerindian descent. We popularize those cases and ignore the far more numerous claims to indigeneity. For instance, does the name Dred Scott ring a bell?
This is the story of how the most marginalized people in America have repeatedly expanded rights for everyone by challenging the country to uphold its founding principles. In 1846, an enslaved man named Dred Scott and his wife Harriet filed the most famous freedom suit.
But for the last 25 years or so, researchers and scholars have been turning their attention to the 300 or so freedom suits that aren't so famous.
Researchers traced my genealogy. Now listen, as a black man with deep roots in the American South, I thought I knew where my story was headed. I was very wrong. In Northumberland County, Virginia, in 1712, before America was America, her granddaughter, my 8 times great-grandmother, Bess, was with her. That's according to this centuries-old deposition that Dr. Murphy's team uncovered. Why a deposition?
So Sarah has a lawsuit that's filed saying we're free.
This is the actual lawsuit filed by Sarah, suing for her freedom and for the freedom of her descendants.
Witnesses apparently said they looked like they were Indians.
Researchers believe that Mary and Bess were actually Matabani, like these people.
The thing is, it was sort of undiscovered history. And because it was undiscovered history, it was a long time getting people to understand the impact of it. Hundreds had petitioned and won. Hundreds had petitioned and lost.
Each case was impacted by the prevailing attitudes of its time, from a slave state defending its grip on slavery to a northern state promoting its newfound freedom.
But these original documents are really the closest you get to their voices. A lot of that gets lost as the process goes on.
That's exactly that's one of the things that actually took my breath away when I first started working with these court records.